morning and welcome back to the Morning Brew here on CNC3. We are going to take a little bit of a dive into the Guardian's lead story today. The appeal court overturns the conviction of Amy Anamanthudo's alleged killer. Amy, had she survived, would have been 19. This happened 15 years ago when she was 4. Marlon King, his conviction has been overturned. I'm being joined by attorney-in-law Martin George just to discuss how do we process this information. The story by Derek Achong details the appeal court's criticism of how the judge in the case, Anthony Carmona, who's the former president, handled or how he instructed the jury to deal with 2 witnesses in particular. King's ex-wife, Luann Davis, who laid out a case of abuse that she faced at the hands of Mr. King, and also a neighbor who testified that he witnessed King abusing the child before. Apparently, the judge should have made it clear to the jury that he was not just a man with poor character, but he potentially had an interest to serve, and his account was actually being questioned for it being true. Martin George, thank you so much for coming on to the program. How do we deal? How do we deal with this story? Us in the public who are not accustomed to law and might find this situation very distressing.
Yes, hi. Good morning to you and good morning to your viewers in Trinidad and Tobago and elsewhere. It is always difficult for members of the public to digest and assess and understand when decisions such as this are made. Now, the reason being that law is, I can explain it as a game that is played by a certain set of rules. And at the end of the day, you sometimes find results which show that it is how you play the game as opposed to what the truth of the matter really was. And that is when I think the public always has a difficulty, and understandably so, quite understandably so, because I mean, I can fully empathize with members of the public who would feel outraged, because when one reads the circumstances of what is alleged in this matter, any normal human being, you'd feel sick to your stomach, you know, to the pit of your core. You would be, you know, upset, outraged, hurt, annoyed to hear what was done to this innocent 4-year-old child. So when you look at that, then of course, you know, the natural thing would be, yes, let's find the person guilty, convict them. However, there are rules which govern that process. And it's always a challenge for a sitting judge. And, you know, in that sense, you know, the headline may be a bit harsh in a sense, because it's always a challenge for a sitting judge to walk that fine line to ensure that you give clear and proper directions to the jury without overstepping or overreaching, you know, into, you know, the arena of the prosecution, and also without, you know, assisting the defense. So in other words, you as a judge, you're on a tightrope. It's a balancing act, particularly for a criminal judge summoned up for a jury in such a scenario. And in those circumstances, there are always things which I think should be there to guide you as to, well, okay, you don't want to make this mistake, you don't want to make this error, and it's always better, I would think, to err on the side of caution and let the jury make their decision as opposed to trying to be maybe over exuberant and in that sense end up, you know, maybe saying something which later becomes a flashpoint for a challenge. And then, you know, you have a ruling such as what occurred in the Court of Appeal where they overturned the conviction based upon, what they consider to be maybe errors or flaws in the summing up given by the judge. Now, we need to understand that the way the legal system works in our jurisdiction is that a defendant always has the benefit of the doubt in that you are presumed innocent until proven guilty. And I want to just explain to members of the public, we need to understand when the legal system, especially the criminal justice system, speaks of finding someone guilty, we need to understand that may have nothing to do necessarily, right? The finding of guilty or not guilty may not necessarily be linked to the actual facts of the case. A finding of guilt is a function of the result of the process in the legal system. Similarly, a finding of not guilty, the same thing. So in other words, we need to understand that there sometimes can be a disconnect between the facts that are presented and the finding that is returned, but that may be simply because of the function of the legal system. I mean, it's confusing and it may not make sense to the layman, but the point is it's a game that is played by certain rules, and the rules are the things that trump it. I mean, a simple and, classic example I like to give people is, for instance, O.J. Simpson. In the minds of everyone around the world, it was clear that O.J. Simpson was, quote unquote, guilty because of the fact that, the evidence showed quite clearly that, look, it appeared that he was there and that he may have killed his ex-girlfriend and her boyfriend, right? However, look at what happened at the trial. Remember, it's the errors and the malfeasance of Detective Mark Furman and the prosecution that ended up leading to the not guilty verdict. Because in other words, the trial got spun into a totally different direction, whereby it then focused on what appeared to be the corruption of the prosecution in their over-exuberance to try to get a guilty verdict, whereby you saw that things such as, the glove, ended up being the pivotal moment in that case. If you remember this sterling address that was given by Johnny Cochran, O.J. Simpson's attorney at the time, where basically he told the jury, if the glove don't fit, you must acquit. And that line stuck in the minds of the jurors, and that's what ended up turning it in OJ's favor.
Thank you for bringing...
It may have had nothing to do with the actual facts of what happened.
Thank you for bringing such clarity for that. And you're very right. I have a visual of OJ holding the ill-fitting glove on his hand, as you said that. And Johnny Cochran's work in that case was absolutely brilliant.
I think it's probably the best closing address in history for a criminal trial.
For sure. I think a lot of people became attorneys just on the basis of that performance.
He was brilliant. He was not the lead attorney. I remember it was Shapiro was the lead attorney. Yeah. But Johnny had to fight in order to be able to get to do that closing address, and he was the man for the job.
And thanks for that, because and that analogy, because it's really, I think a lot of people get confused with why you have to go through these processes, and it's like, we can see it clear as day, and still you're going to let this person off on a technicality. Based on, let's switch tack to another technicality. So Mario's apparently is telling its employees, we are getting ready for reopening on Monday. Let us know which ones of you are vaccinated, and if you're not, we can't bring you out at the moment. Now, the government has not made an official, has put out an official position on whether it's going to allow mandatory vaccinations. They seem to not want to. What does this leave for private entities? Are they within their right to do this?
Okay, so you see, it's a very, very dicey and touchy subject, and I think that's the reason why you notice the government is, it's sending messages and signals, but not coming out with any clear decision that, look, they are going to legislate in order to vaccinate, because it's not an easy decision to make, and it's going to create mass reactions all over the country, some in favor, some against. You will have persons filing constitutional motions. You will have those who will file applications for judicial review. They will claim that their constitutional rights are being infringed. So it's a very, very touchy subject in terms of governmental intervention to say that you are going to legislate to vaccinate. So I think that's why you see the government is, basically stepping gingerly around the issue. Of course, it's sending its signal as to what it would like, because you heard from the Prime Minister himself, vaccinate to operate. So basically, he's trying to suggest to persons, hey, listen, you need to be vaccinated in order to, be able to
But Martin,
operate
I
or
have
function
to
in
ask,
a business.
the government is stepping gingerly. This fast food company is making a decisive position on the issue.
Right. Okay. So in other words, they are basically saying, listen, and of course they themselves are still trying to approach it carefully, because from what I see, they are saying, look, we want our employees vaccinated in order to be working in our establishments. And what they are saying is that if you are not vaccinated and if you don't intend to be vaccinated, then we will not roster you for work. So they're not saying that they're terminating you or they're firing you or anything of the sort. They are simply saying we will not roster you for work. So in other words, you are still, quote unquote, and technically an employee. However, if you're not called out to work, then, clearly you're not paid. So, if that situation continues for months, going into a year or so, then, at some point you yourself will say, am I really employed? Have I been fired? Have I been let go? If you understand me. So there's that side of it. But I think their approach, the approach of the company, is that, look, we are not saying we're terminating you, and we're not saying that we're trying to force you to be vaccinated. But just bear in mind, this is the system we will be operating. I think there's a major seller of fried chicken who has also taken a slightly similar position, in that they are also saying that, look, they will roster vaccinated workers in priority to their unvaccinated workers. Now, let me just give this some historical context, Soini, because it's always good for us to, have recourse to the law, and let's look back and see what has happened. If we recall, when you look back in history, think of things such as the smallpox epidemic, which ravaged, several countries around the world. Remember, in 1853 in the UK, they actually had to implement legislation to make smallpox vaccination mandatory. We need to remember that, because the effect of the smallpox virus was so damaging and devastating. They actually legislated making it mandatory. Interestingly enough, in response to that mandatory vaccination legislation, there were several anti-vaxxers and anti-vaccination leagues which formed in Britain. So, let's understand this. We're talking more than 150 years ago. And you have a similar type of scenario as to what you have with those who are vaccine hesitant, vaccine resistant, and the outright anti-vaxxers. So this is not an entirely new type of situation that the world is facing. But because of the damaging and devastating effects of the smallpox virus, in the UK, they passed the legislation making smallpox vaccination mandatory.
So Martin,
we also have to remember, and it's important for Trinidad and Tobago to remember this and understand that even here in Trinidad and Tobago, we do have historical precedent for this. And that's why, and I always say, the law is so important, and it's so...
It is very important, and history keeps repeating itself. But
sorry?
I said law is very important, and history keeps repeating itself because, you know, if we go back, we will figure out, well, this is how our forefathers and other jurisdictions dealt with this. We spoke about the government's reluctance to say this is our definite position. We spoke about businesses' concern and how some are dealing with it in a kind of, you know, not too direct way, but in a pretty direct way. What is the recourse that employees have?
Right. So the question would be, in terms of a situation such as that, you know, and I mean, we heard the president of the industrial court, Deborah Thomas Felix, earlier in the year, you know, she made a pronouncement where she said, look, an employer cannot unilaterally alter the terms and conditions of employment in order to, you know, change it in such a way to now make vaccination a mandatory requirement for returning to work. So that's why I tell you, it appears to be a very you know, clever way of not saying that it's mandatory to return to work, but simply saying, well, listen, if you're not vaccinated, you will not be prioritized on the roster. So, you know, it's a tricky thing. But there are ways that employers can look at it, employees also. Say, for instance, we have the Occupational Health and Safety Act, which mandates that an employer must present a safe place of work for his employees. So there would be some employers who would say, look, I'm relying on Section 4 of the, I'm relying on the Occupational Health and Safety Act as my basis for saying that I must provide a safe system of work, a safe place of work for my employees. So that's why I would want everyone to be vaccinated if they're working in my establishment. However, you also have, for instance, cases and authority also from the industrial court, separate and apart from the statement from the president, Deborah Thomas Felix. You have, for instance, the case of Communication Workers Union versus National Training Agency, where it was held that, look, the term of employment cannot be changed or altered unilaterally. And this is in keeping with the principles of good industrial relations practices. So in other words, while you may want to insist on it, they're saying that if it amounts to a fundamental change in the terms of employment, then an employee can have recourse to the industrial court and say, listen, this is a fundamental change in my term of employment, and therefore I'm seeking redress because essentially I am fired. If you understand me, because that basically could amount to what you would call constructive dismissal. If I have been put on leave, or I've been rotated out of the roster on an almost permanent basis, then effectively I've been constructively dismissed. So employees can look at it from that perspective, you know, so I'm just trying to give some balance. I mean,
and we appreciate that, I think. For
employers, and I'm giving you the law to show for employees also.
Thank you so much, Martin George, for joining us this morning to offer clarity.
Just one last thing I just want to touch on for Trinidad and Tobago and for the benefit of everyone. We need to just bear in mind that we also have legislation in Trinidad and Tobago which covers situation of mandatory immunization. Section 5 of the Public Health, Nursery Schools and Primary Schools Immunization Act, Chapter 2803 of the Laws of Trinidad and Tobago, that provides for that. So that covers situations where, for instance, school children are required to be immunized against certain diseases in order to be able to attend school. So we do have precedent, we do have laws that can guide this, and certainly, Soyini, we must develop this topic further in a subsequent interview, because it's very important for the public to know their rights and their responsibilities.
Yeah, no, definitely. That's clearly what is required. Martin George, thank you so much for joining us.
Always a pleasure. Have a great morning.
Same to you. Same to you. All right, we're going to take a very quick break, but when we come back, the other pressing issue that we have to deal with, the potential reopening in schools in September, that has already gotten on a rocky start. So we'll be speaking to the opposition Shadow Education Minister, Anita Haynes.